ॐ भूर्भुवः स्वः तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात्। ॐ भूर्भुवः स्वः तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो ॐ भूर्भुवः स्वाहा तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात्। ॐ भूर्भुवः स्वाहा तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि
The fiscal, audiencia, and governor should act in equito, in that way, avoiding friction and quarrels over jurisdiction. 168. That the audiencia did not always try cases relating to the Indians with requisite promptness is evidenced by the many and repeated letters of the king to the tribunal, to the fiscal, as protector of the Indians, and to the regent, chiding these officials for delay. On many occasions the royal zeal for justice in the treatment of the Indians, based on a lack of knowledge of the true nature of the Filipino, completely overruled all considerations of practicability and common sense. As an illustration of this, on June 20, 1686, certain natives of the province of Bulacan sent false evidence to the Council of the Indies. This testimony was taken in preference to that remitted by the audiencia, the decision of the latter body being reversed by the Council of the Indies. The audiencia refused to allow the execution of the new judgment. The oidores all offered to resign in protest, and the regent, at the risk of removal, reopened the case. It was proved, by the testimony of a number of officials and by the confessions of the natives who had perjured themselves, that the evidence upon which the council had acted was false. 169. A record of these proceedings was remitted to the council, and that tribunal promptly reversed its former decision. Further illustrations of the authority of the audiencia in cases involving natives may be seen in suits which arose from time to time over the illegal treatment of the latter by the friars and the unjust occupation of the natives' lands by the religious orders. These suits afford illustration, also, of the services of the audiencia as an agency to force persons to show their titles to lands which they held. 170. This jurisdiction will be given more detailed treatment in the proper place, but the brief citation of one or two cases among many seems advisable to illustrate the activity of the audiencia in protecting the Indians, both by trying suits involving them and by actually intervening in their behalf. Various revolts broke out among the Indians near Manila from 1740 to 1750. These insurrections were said to have been provoked by the encroachments of the Augustinians and Dominicans on the lands of the natives. The matter was called to the attention of the home government, and Pedro Calderon Enriquez, an order, was ordered to investigate the charges made against these religious orders and to ascertain the validity of their claims to the lands in question. The friars, when ordered to submit titles to a secular judge, refused to comply, claiming ecclesiastical exemption. In the face of their opposition, Calderon dispossessed the friars of the lands which they were said to have usurped and which they were continuing to hold without legitimate title, restoring the lands to the crown. The case was appealed to the audiencia, and that tribunal upheld the visitor. Calderon also found that the University of Santo Tomas and the Dominicans, in collusion with a clerk of the audiencia, had taken lands from the native town of Salang in 1743. Calderon restored the lands to their rightful owners, and his act was approved in judicial review by the audiencia. The friars took exception to this by appealing to the Council of the Indies. The council notified the audiencia of its affirmation of the judgment of Calderon and further stated that the lands of Salang, Imus, San Nicolas, and Cavite had been unjustly seized and should be restored. This was not only an affirmation but an extension of the sentence of the order made by the council after the royal fiscal of the Council of the Indies had reviewed all the evidence presented in the case. This suit shows the efforts made to carry out the royal intention that the natives of Spain's colonies should be justly treated. It also shows the respective jurisdictions of the audiencia and Council of the Indies as courts of review and appeal in adjusting dispute between the Church and the Indians. In addition to the above, the audiencia exercised jurisdiction over the religious themselves, both as individuals and as subjects of the king, punishing them for violation of the civil laws of the realm to which they were amenable as subjects. An illustration of this is furnished by the following case, which occurred in 1617. 2 Augustinian provincials were murdered. 1. Fray Geronimo de Salas, by poisoning, and his successor, Fray Vicente Sepulveda, by strangulation. A tribunal of friars composed of 9 prominent members of the Augustinian order, was appointed by the bishop for the investigation of the crime. This body, after due consideration, caused 6 members of the order to be apprehended. 4 of them were believed to be guilty of the murder, and 2 were suspected of connivance at the crime. On July 31, 1617, these 6 culprits were handed over to the civil government, and on September 2nd of that year, the 4 guilty ecclesiastics were condemned to death by the Audiencia, while the other 2 were sentenced to 6 years of service in the galleys. This case illustrates the extent of ecclesiastical jurisdiction exercised respectively by the church and government tribunals under the Fuero Mixto. 171. The former, on this occasion, made the preliminary investigations and handed the culprits over to the secular authority with recommendations. The latter conducted the trial, passed sentence and saw to its execution. The trial and conclusion of this case covered the remarkably short period of 33 days. 172. Speaking generally, the authority of the Audiencia over ecclesiastical affairs extended to disputes between orders, between the government and the church, or its representatives, to cases relating to land, titles, to those alleging abuses of the Indians by the friars, to cases involving the royal patronage, and to cases of fuerza. 173. As the question of the ecclesiastical jurisdiction of the Audiencia will be discussed more fully in subsequent chapters, no effort will be made at this time to particularize concerning its authority over church affairs, it being merely desirable to suggest the fact here that the Audiencia had jurisdiction in suits involving the church in the civil government and in those which had to do with the protection of the natives from the abuses of the ecclesiastics. Records of thousands of cases exist to show the different kinds of suits tried judicially in the Audiencia. Civil and criminal matters came up in the tribunal as in all other courts of law, and hence, as such, merit only passing attention. Among civil cases possibly the most typical were those relating to encomiendas. It must be borne in mind that the Spaniard, however mistakenly from the theoretical point of view, regarded the encomiendas as property in the same sense as a modern farmer regards his farm as property. He paid a rental or tax to the government. He engaged in agriculture for gain, and, as we have seen, the moral duty of protecting, uplifting, or educating the Indians rested but lightly on his conscience. Therefore, as these cases are discussed in the following pages, the value of the property, and not the treatment of the Indians on the encomiendas is the first consideration. As already stated, the law of lien reserved for the Council of the Indies final action in all encomienda suits involving more than 1,000 ducats. 174. Many suits involving encomiendas came up prior to the establishment of the Audiencia. The defects apparent in the trial of these cases by the governor show clearly the need of an Audiencia at that time. The earliest case noted in this connection was prosecuted in 1580 by the assessor of the governor against Dona Lucia de Loxa, the widow of an encomendero, with the object of dispossessing her of an encomienda held at Butuan, Mindanao. 175. She was charged with having nullified her title by marriage to another encomendero, since the law forbade married women to hold encomiendas. In her defense she alleged that the desire of the governor to enforce the law was only pretense, since many married women in the Philippines held encomiendas. She stated that the governor desired to deprive her of her property in order that he might bestow it upon a friend. This case was carried to the Council of the Indies, and it illustrates the effectiveness of the law of liens, which took from the governor authority over a case in which he was interested and gave final jurisdiction to the tribunal in Spain. The papers pertaining to this case were returned to the governor with orders to do as the law commanded. The defendant was accordingly removed from the encomienda. Another case was disposed of in a slightly different manner. On January 22, 1581, Juan Gutierrez de Figueroa, second husband of Magdalena Rodriguez, widow of an encomendero of Mindanao, filed suit before the governor praying to be continued as possessor of an encomienda which his wife had held prior to her marriage to him. He brought the suit on the grounds that he was a soldier and was accordingly deserving of reward. This case, in accordance with the provisions of lien, came within the jurisdiction of the governor. He denied the petition, but the soldier appealed the case to the Council of the Indies, and that tribunal again reversed the decision of the governor on May 23, 1584. In January 1582, Bishop Salazar, as protector of the Indians, brought suit before Governor Ronquillo de Penalosa against Juan de Ayala, a Spaniard holding various encomiendas in different parts of the island of Luzon, but resident in Manila. Two specific charges were brought against Ayala. He was said to have reduced the Indians on his encomiendas to the status of slaves, which was forbidden by the law of November 9, 1526. 176. He had also violated the law, which prescribed that encomenderos should live on their encomiendas, 177, and give their personal attention to the Indians thereon. Ayala added testimony to prove that this law was a dead letter and that it was disregarded by most of the encomenderos. He even showed that there were many of them residing in Spain who held encomiendas in Spain and Peru. Governor Ronquillo felt that the evidence at hand was insufficient to justify decision in this case, so he permitted it to be carried to the Council of the Indies. The latter tribunal rendered its decision on June 24, 1584, communicating to the Audiencia of Manila its ruling that Ayala should be allowed to retain the encomiendas in question, but the president and employers were especially charged to enforce the law prohibiting slavery in the Indies. The procedure in these cases confirms the laws already alluded to, which were promulgated before the establishment of the Audiencia, that the governor should have jurisdiction in suits involving less than 1,000 ducats, with appeal to the Council of the Indies. It would also appear, from the data at our command, that the Audiencia inherited the governor's former authority in these matters. During the period from 1583 to 1589, and after the re-establishment of the Audiencia in Manila, this tribunal exercised authority over suits involving encomiendas. There is so much sameness in the nature of these cases that little would be added by describing them. There appears evidence of considerable conflict of jurisdiction, however, between the governor and the Audiencia over the adjustment of the latter to the new situation relative to the encomiendas. Governors Acuna, Tello and Collado sought on various occasions to retain jurisdiction over suits involving encomiendas on the basis of the law of lien, notwithstanding the fact that the Audiencia had been given the duty of trying such cases. When appeals were made to the Council of the Indies, that tribunal made clear its determination that the Audiencia should try suits involving encomiendas, but that in administrative matters relating thereto the will of the governor should prevail, unless his decision were contested through legal channels. An illustration of such difference of opinion may be noted in a letter written by Governor Juan Nuno de Tavera on August 4, 1628, to the Council of the Indies. Tavera complained of the action of the Audiencia in regard to the disposal of a case involving an encomendero who had married the widow of another encomendero, and who had tried to unite and hold both their encomiendas after marriage. The governor contended that two persons holding encomiendas by previous rights should choose the more desirable one and relinquish the other, in accordance with the practice in other places. Especially should this be done in the Philippines, he held, because there were so few encomiendas in the islands. The fiscal approved of this suggestion and made a motion before the Acuerdo of the Audiencia that this course should be pursued, but, as no laws had been promulgated on the subject, there was no precedent to follow. The Audiencia accordingly declared that such a course as the governor had suggested would not be legal. Tavera petitioned the Council of the Indies for a ruling on the subject. The Council sustained the governor in its consulta of January 15, 1630. There was apparently no limit to the value of suits involving encomiendas which might be tried in the Audiencia and appealed to the Council of the Indies. There exists the record of one case in which the encomienda was valued at 223,000 pesos. In this suit, the fiscal proceeded against Don Juan Emil and Francisco de Rebolledo, residents of Mexico, for possession of an encomienda held in the Philippines. This case affords an illustration of the delays to which the course of justice was subject, it being appealed to the Council of the Indies in 1612, and not finally settled till 1620. A suit involving an encomienda valued at 430,102 pesos came before the Audiencia in 1703, when two residents of Manila, named Delgado and Aboria, were dispossessed of an encomienda by the governor. The encomienda was awarded immediately to Juan de Echevarria and Antonio de Indara. The latter were prosecuted in the Audiencia by the dispossessed encomenderos, and the tribunal, in compliance with the law of May, made the prescribed investigation, recommending that the governor's action should be disapproved, since the evidence showed that the persons installed on the encomienda were distant relatives of the governor. The council adopted the recommendations of the Audiencia in this case, ordering that the original encomenderos should be restored to their estate, and that this breach of royal commands should be registered against the governor to be answered in his residencia. Another suit, of a similar nature to that described above, was brought in the Audiencia in 1713 against Juan de Rivas, who had been assigned two encomiendas in Leyte and Cebu, respectively, by the governor, thus depriving one Sarmiento who had held them formerly. The plaintiff claimed that he had made great improvements on these estates, spending all his income thereon, and as yet had received no profits from the land. He petitioned, therefore, that these encomiendas should be bestowed upon him for another term. 178. The Audiencia withheld its judgment on this case, referring it to the council. That body, after seeking the advice of the royal fiscal and contador, recommended to the king that Sarmiento should be allowed to retain the encomiendas for another term, and it was accordingly done, a royal order to that effect being expedited on May 29, 1715. It is notable how frequently the action of the Audiencia or that of the governor was confirmed by the Council of the Indies. In most of the cases which have been described, the original papers, including letters, autos and testimonials, each exceeded 179, containing from 100 to 2,000 pages, are marked seen by the council, action of the governor confirmed, or no action to be taken. The original decisions being thus confirmed, it may be concluded, therefore, from this brief study that the Audiencia had appellate jurisdiction as a court of law over suits involving encomiendas, and, furthermore, that the tribunal acting in that capacity placed a very effective and definite check on the governor in his executive control over encomiendas. Property suits, aside from those involving encomiendas, were numerous. One noted case may be cited in which the heirs of Governor Fausto Cruz y Góngora in 1703 brought suit to recover money owed by Gaspar Sanchez and Bernardo de Gueros to the ex-governor. The Audiencia failed to award the sum, which approximated 8,000 pesos. The case was appealed to the Council of the Indies and the decision was reversed, the plaintiffs being awarded the money originally sued for, with costs of suit. A similar case was brought by the children and heirs of Governor Bustamante against Juan de Nebra, general of the Galleon. The case was tried in the Audiencia and the tribunal decided in favor of the defendant. The case was appealed to the Council of the Indies and the decision was reversed. 180. In 1736 Gaspar Combe, a Frenchman, sued the estate of a deceased debtor, Juan de Olard, for 2,000 pesos. 181. The case was appealed to the Council of the Indies, and fully 200 pages of documentary material exist, carefully annotated and digested, to show how thoroughly and with what formalities suit of even that small import was tried. We have already noted the tendency of the government to discourage the appeal of property suits to the Council of the Indies. The jurisdiction of the Audiencia was final, for the most part, in suits involving sums from 200 pesos to 6,000 pesos. As matters of trade were always important in the life and politics of the islands, commercial suits commanded a large share of the attention of the Audiencia. Up to 1769 the jurisdiction of the Audiencia was supreme in matters relating thereto. 182. But on December 13th of that year, a consulado was established at Manila, thereby relieving the Audiencia of much of its former control over commercial affairs. 183. The consulado, from the time of its establishment, was an ever-present thorn in the side of the Audiencia, and conflicts over the respective jurisdictions of the tribunal. 184. Were continually arising. We may briefly cite one or two cases to illustrate the respective jurisdictions of the Audiencia and the tribunal of the consulado. On December 26, 1806, action was brought by two Spaniards against the British firm of Jacob Smith and Company on account of the inferior quality of goods sold to the plaintiff by that firm. 185. Suit was brought originally in the Audiencia, but the consulado applied to the governor for jurisdiction in the case on the ground that, as a commercial suit, it should be tried in the consulado. 186. The governor awarded jurisdiction to the Audiencia. The consulado reappealed the case, but the council sustained the governor's decision on the ground that this was a suit between a private individual and a merchant which should be tried in the Audiencia, the tribunal which usually tried cases between individuals. The function of the consulado, the royal decree stated, was to try suits of a commercial character, which arose between merchants. 187. An occasion on which the jurisdiction of the Audiencia was unquestioned may be noted in the suit which was appealed to the Council of the Indies from the Audiencia in 1698, over the wrecking of the galleon, San Francisco Xavier. The Admiral, Don Esteban Ramos, was held accountable for the silver carried on the ship, and the merchants of Manila sued him for what they had lost in the wreck. 188. It was charged that Ramos had landed the silver, but was seeking to conceal that fact, claiming instead that it was lost. The case was appealed to the council by the defendant. 189. The council referred the case to the Junta de Guerra. 190. And that tribunal reversed the decision of the Audiencia, declaring that Ramos was a faithful servant of His Majesty, and still a poor man. There was no possibility of his having the silver. Ramos was transferred to the Atlantic Flota. 191. The royal fiscal, in the opinion rendered for the guidance of the junta, made the comment that frequently the oidores of colonial audiencias were influenced, against their own ideas of justice, by the opinions and wishes of the most powerful residents. Such was possibly the case in Manila on this occasion. This statement at least shows that those in control at Madrid were aware of some of the fundamental weaknesses of the colonial audiencias. Another typical case, indirectly connected with commerce, occurred in 1713, when the fiscal of the Audiencia prosecuted three captains, Enrique Boydant, Fernando Gall and Diego Brunet, who had arrived at Cavite in command of French merchant and exploring ships, without the royal permission to trade in the islands. These captains, who were foreigners, of course, were charged with smuggling, and were brought before the royal Audiencia. The charges against them were not proved, and in due time the cases were dismissed. 192. The laws of the Indies authorized the governor and the alcaldes del crimen to try cases of strangers. 193. But in Manila, where there were no magistrates of this category, such cases were tried by the Audiencia. Perhaps the most important commercial suit that was ever tried in the Audiencia of Manila came before that tribunal in 1656, when several residents of Mexico were excluded from the use of the galleon and their goods confiscated. This action was in accordance with repeated siege laws and regulations which reserved the space in the galleon for the exclusive use of the Manila merchants and authorities. Mexican traders, who had from time to time shipped goods on the galleons, were forbidden to crowd out the Manila merchants, who depended on that trade exclusively. The fine levied on this occasion amounted to 273,133 pesos. The case was appealed to the Council of the Indies. The aforesaid decision was upheld, and the sum was finally ordered, paid in Mexico. 194. During the greater part of the Audiencia's existence there was no consulado in Manila, and the jurisdiction of the Audiencia in commercial cases extended to suits between merchants for space on the galleon. The tribunal had jurisdiction over the trial of officials for dishonesty in the assignment of galleon space, investigations of officials charged with preserving more than their due share of space, and such other cases as are mentioned in the laws of the Indies as being the concern of the consulados of Lima and Mexico. 195 officers of the galleons were tried for mistreating seamen, for smuggling, for exceeding the limit of merchandise allowed, for giving passage to lewd women and to persons traveling on the galleons without permission. They were tried for carrying more slaves than they were allowed by law to carry, for charging exorbitant prices of passage, and for failing to turn in accounts of money collected. Commanders were often held criminally responsible for carelessness in navigation and for shipwrecks. These cases were tried in the tribunal of the Consulado after 1769. The Audiencia had appellate jurisdiction over all residents of the colony, both natives and Spaniards. All crimes committed within 5 leagues of the city of Manila were ordered to be tried by the oidores, in first instance, 196, but unless they were of extraordinary importance, special investigators, usually alcaldes mayores or alcaldes ordinarios, were delegated to try them in the name of the Audiencia. 197, as already stated, most of the criminal cases arising in the colony were tried in first instance in the provinces by the alcaldes mayores. Cases appealed to the Audiencia were reviewed in that tribunal. The trial consisted of an examination of the summary, or abstract of the case as it was originally tried by the lower judge, and, if errors were found to exist, the decision was either reversed, or the case was remanded to the judge who first had tried the case, for second trial. 198. The Audiencia did not try the case with the defendant present. It merely reviewed the proceedings of the lower judge. Criminal cases were not ordinarily appealable to the Council of the Indies. The procedure in criminal cases was generally so similar to that already described that it is unnecessary to give any illustration of the Audiencia's criminal jurisdiction. Most of the cases that eventually reached the Audiencia involved Spaniards, native caciques, and half-castes. Natives who were charged with robbery, murder, and crimes of a depraved nature were usually of the class unable to finance appeals to the Audiencia. This fact probably accounts for the scarcity of criminal cases appealed during the first 2 centuries of the Audiencia's existence. 199. However, the reforms of the 19th century brought an increased number of cases into the Audiencia by systematizing the administration of justice, differentiating the judgeships from administrative offices, and providing for greater facility of appeal. 200. It is probable that in criminal as well as in civil cases, Spaniards derived considerable benefit from the fact that the Audiencia was composed of magistrates of their own nationality. High officials, no doubt, escaped the consequences of their misdeeds more easily than did men of more modest social and political attainments. This is shown by the well-known case of the murder by Governor Fajardo of his wife on July 21, 1621. This came up before an Audiencia which was composed of judges who were largely under the governor's domination. The tribunal gave the matter a cursory investigation, after which the governor was allowed to go unpunished. 201. We shall see that proceedings were different, however, when officials under investigation were charged with offenses against the government. The Residencia, which dealt with such charges, was a pitiless form of inquisition in which the officiating magistrate was in duty bound to find his victim guilty, if possible. Criminal cases of a character slightly different from those described above were prosecuted by the government for the infraction of any governmental regulation, or for the evasion of the payment of taxes or duties. The collection of revenues devolved upon the oficiales, reals, and they were ordered to accomplish their duties in this particular, if possible, without the assistance of the courts. 202. Numerous cases did come up in the Audiencia, however, involving the prosecution of individuals for violations of the Alcabala, Quinto, and the tax on the export of silver, Conusos. Persons assisting in the apprehension of violators of these laws were rewarded with a part of the proceeds of the fine, the remainder becoming the property of real hacienda. On October 6, 1783, the final jurisdiction in cases of smuggling and non-payment of the King's Fifth was taken from the Audiencia, appeals being authorized to the Council of the Indies. 203. Reference has already been made to the services of an order as Special Auditor de Clara. This, as well as other matters relating to the jurisdiction of the Governor and Captain General over military matters, wherein the Audiencia had no authority, will be noted when an examination is made of the relations of the Governor and Audiencia in a subsequent chapter. Suffice it to say here that the Audiencia did not have jurisdiction as a court over soldiers or military affairs closely related to the subject of the defense of the islands, and the exercise of judicial authority over soldiers was a special jurisdiction which the governor had over matters relating to the Chinese. This subject will be treated in greater detail when we discuss the relations of the Audiencia and the governor. During the first 2 centuries of its existence, the Audiencia had jurisdiction as a judicial tribunal in the cases and instances which have been noted. It had civil and criminal authority, original and appellate. Its decisions were final in civil suits on claims for 6,000 pesos or less. Criminal cases were settled in the Audiencia. The judicial authority of the Audiencia was impeded during the greater part of its history by the failure of the government to entrust it with complete jurisdiction in all civil and criminal matters, and by the tendency of the latter to interfere in matters of minute and insignificant detail, which should have been left to the magistrates of the tribunal. The Constitution of 1812 and the reforms made in pursuant thereof really effected the changes which had long been needed. The Audiencia's jurisdiction was made final in all civil suits, and increased in administrative cases. Thereafter no appeals were made to the Council of the Indies unless they involved administrative law. Cases involving official dishonesty, incapacity, residencia, pesquisas, treason, disputes between audiencias and other tribunals, over conflicts of jurisdiction, and questions of the interpretation of the law were still carried to Spain. These were important steps for the improvement of colonial judicial procedure. They served to simplify it, preventing a multiplicity of cases from being carried to Spain which should have been settled within the colony. These tardy reforms left to the home government more time in which to occupy itself with questions of governmental policy, leaving to the Audiencias more authority and responsibility in purely judicial matters, thus giving to them a greater prestige in the commonwealth wherein they were situated. The qualifications for the magistracy were also raised at this time, although it cannot be said that the magistrates of the Audiencias were at any time incompetent or lacking in ability. The Audiencias of the colonies were given equal status with those of the peninsula, and were thus elevated in dignity and standing to the rank of tribunals of the first order. The chief defects of the colonial judicial system of the 17th century were thus corrected, though somewhat tardily. It is unfortunate indeed that these changes applied only to a mere skeleton of Spain's former colonial empire. In this chapter we have discussed the Audiencia as a formal court of justice, with methods, practices, and traditions little different from those of any tribunal of justice. However, it had judicial authority, more extensive and far-reaching than has yet been indicated. Among the different kinds of cases over which the Audiencia had jurisdiction, perhaps none was more important, and certainly none was more exclusively peculiar to the Spanish judicial system than suits of residencia. So distinct and extraordinary was that phase of judicial activity that it merits consideration apart from a discussion of the Audiencia's functions as an ordinary court of law. In the following section we shall note its jurisdiction as an administrative court over suits wherein the government was a party and wherein the object was not only to punish offenders, but to act as a preventive of official misconduct. Chapter 4. Judicial functions of the Audiencia. The Residencia 204. The purpose of the Residencia was to uphold the morale of colonial service by making officials answer for all their acts in the judicial examination held at the close of their terms. It may be said that the fear of the Residencia was almost the sole incentive to righteous official conduct or efficient public service, and it will be seen that the Audiencia exercised very pronounced authority in this. Indeed, the Audiencia had general supervision in a semi-judicial capacity over the services of officials and public servants in the colonies. It was the function of the Audiencia to send reports to the court relative to the conduct, work, or attitude of any employee or official of the government, or of any resident of the colony. These reports were known as informations, pareceres, de servicio. 205. The tribunal itself was ready at all times to hear complaints against provincial governors and judges, treasury officials, magistrates, governors, or, in fact, any and all officials holding their positions by virtue of the King's commission. 206. Charges might be made by a wrong party or by anyone whose knowledge of an abuse was sufficient to justify charges. Heavy penalties were imposed upon persons making false or unsubstantiated charges. 207. Complaints against alcaldes, mayors, and corregidors were most likely to be made during the regular investigation of the visiting order, which, as we have noted, occurred every 3 years, but sufficient complaint might be made to justify the dispatch of a special investigator at any time. 208. The findings of the above inspections might be reviewed by the Audiencia and lead to the suspension and dismissal of the official under investigation. 209. The final action had to be confirmed by the Council of the Indies in case the person concerned were a royal appointee, but in these matters the action of the local officials was usually approved. For the removal of auditores and oficiales reals, a slightly different method was pursued. A magistrate of the Audiencia was designated to investigate the case, the evidence was submitted to the Council of the Indies, and final action was taken by and not by the Audiencia. 210. Any and all charges brought against an official in these investigations, even though he were cleared at the time, might be revived in the Residencia. Suspensions from office were made by the governor with the advice and consent of the Audiencia. The governor had the legal right to make temporary removal, but on account of the seriousness of such an act, and the considerations depending upon it, he usually preferred to have the support of the magistrates in the matter. The governor, as vice patron, could suspend prelates and other church officials, but he seldom, if ever, exercised his powers to the full extent. The Audiencia, at Manila, on the other hand, actually drove the archbishop from the city on various occasions. The suspension and the removal of members of the ordinary clergy from their districts was a frequent occurrence, but churchmen were not subject to Residencia. The Audiencia had no authority to suspend or remove the governor, though the magistrates could infrequently did bring charges against the governor which led to his dismissal. Governors actually suspended and removed auditores at times, though such acts were protested as violations of the law which authorized only the Council of the Indies to remove these officials. Briefly, the procedure in making these removals was as follows. The governor and Audiencia investigated the conduct of an official, whenever circumstances demanded it. The latter was either suspended and recommended for removal, such recommendations being made by the Audiencia to the governor or to the Council of the Indies, according to the rank of the official, or the tribunal could make the removal itself. 211. If exception to the action of the Audiencia were taken, all the papers relative to the case were forwarded to the Council of the Indies, and if good reasons were found to exist for the action of the lower court, the Council approved its action. 212. This was not the Residencia as usually considered. Of the various authorities at our disposal, Bancroft gives the most acceptable characterization of the Residencia. He defines it as an examination held, or an account taken, of the official acts of an executive or judicial official within the province of his jurisdiction, during the term of his incumbency. This, Bancroft says, was done at the expiration of the term of office or its stated periods, or, in case of malfeasance, at any time. 213. The principle underlying the institution of the Residencia was bequeathed to the Spaniards by the Romans, being similar to and probably derived from their law, which gave the right of accusation to any Roman citizen against an office holder. The residencia was conducted by a judicial official, and it combined the features of a general survey of the career of the official under investigation, an auditing of his accounts, and a formal trial. Its purpose was to ascertain whether or not the official had faithfully executed his duties, and it served to clear him if he were proved honest, giving him a clean certificate of recommendation. If he were found guilty of official misconduct or dishonesty, he was apprehended, degraded, and punished according to his deserts. Professor Bourne has written in regard to the residencia. The residencia was an institution peculiar in modern times of the Spanish colonial system. It was designed to provide a method by which officials could be held to strict accountability for all acts during their term of office, to allow a contest in the courts involving the governor's powers during his term of office would be subversive of his authority. He was then to be kept in bounds by realizing that a day of judgment was impending, when everyone, even the poorest Indian, might in perfect security bring forward his accusation. In the Philippines, the residencia for a governor lasted 6 months and was conducted by a successor, and all the charges made were forwarded to Spain. The Italian traveler Gemelli Carreri, who visited Manila in 1696, characterizes the governor's residencia as a dreadful trial, the strain of which would sometimes break their hearts. Professor Bourne stated that it was the opinion of de Pons that the severities of the residencia could be mitigated, and no doubt such was the case in the Philippines. By the end of the 18th century, the residencia seems to have lost its efficacy. 214. It is important to note at the outset that the residencia was not conducted periodically alone, but that it might be held at any time in the career of an official. The term pesquisa was applied to the form of residencia which was carried out by a special investigator, pesquisitor, sent when serious charges were made against the conduct of an official. 215. In the investigation which took place, the official might be fined, or if grave offenses were proved, he might be removed from office. Appeals might be made from the pesquisitor to the audiencia and to the Council of the Indies. In fact, the judgments of the pesquisitor were always reviewed in the local tribunal unless the investigating judge had been commissioned by the Council of the Indies. The distinction which has been made here between the formal residencia, which occurred at the close of the term of office, and the pesquisa, which might take place whenever serious charges were made, was first emphasized in laws promulgated by Charles V in 1538, and by Philip II in 1591. These aim to put a stop to the excesses of certain governors, corregidors, and ministers of justice, who, relying on the practice then prevailing of taking residencias only at the close of the official term, had committed unlimited excesses. The new laws, above referred to, stated that although it had never been the royal wish that residencias of royal appointees should be taken without notice having been sent first to the monarch, the above circumstances had made it necessary for them to be taken when charges were made. This sigilla, therefore, authorized the taking of residencias whenever the best interests of the service required it. 216. This sigilla was followed by another which forbade the sending of special investigators or judges of residencia against governors of provinces, unless persons of responsible character presented charges against them, giving bonds to cover the costs. An investigator was thereupon sent to conduct the trial of the official under examination. 217. This matter is covered in slightly different terms in the law of June 19, 1620. According to that enactment, a receptor 218 might be sent to conduct the preliminary investigations of corregidors and ordinary justices when these demanded instant attention and could not await the formal residencia. If, as a result of this inquiry, the guilt of the official seemed apparent, a more complete investigation was made by a judge appointed by the President and audiencia in equito. 219. The authority to determine whether cases merited investigation or not and whether an inquiry should be made belonged to the equito, while the designation of the judge rested with the governor. 220. The judges sent on these missions were not at first authorized to pass final sentence, their decisions being subject to review in the audiencia before execution. However, by the law of May 5, 1576, this added authority was bestowed upon the auditors who conducted special investigations or residentias. 221. Appeals might be made to the audiencia and, if the sentence imposed the death penalty or permanent removal from office, the appeal might be carried to the Council of the Indies. 222. The final approval of the council was required before action could be taken with regard to any royal appointee, except in those cases wherein the fine did not exceed 1,000 pesos. 223. The oidores, it seems, did not always act as impartial judges when entrusted with these investigations. They were often influenced by the extra reward obtained for these services, and frequently by prejudice against the officials under investigation. Such were the charges implied by Governor Fajardo in 1619 when he wrote, "It is always to be believed that the auditors, oidores, to whom the inquiries are entrusted, ought to make them, not only as judges, but as interested parties, so that sinister inquiries should not be sent to your Majesty's Royal Council to defraud your royal treasury and the merits of those who have served well. I assure your Majesty that I have heard that many inquiries have been made, with less justification than might be advisable." 224. A typical illustration of the jurisdiction of the audiencia in an investigation of this sort, and of the delay to which the minor officials were subjected, is shown in the case of Antonio Pimentel, governor of the Marianas, 225, whose residency was taken in the decade following 1711. In this case may be seen the distinction between the formal residencia, conducted at the close of the regular term of office, and an investigation of charges brought during the incumbency of the official. This case illustrates both forms of investigation, for it originated in a charge of treason brought against Pimentel, who, it was said, had furnished food and water to the crews of 2 English vessels, enemies of Spain, and subsequently these same ships had captured the galleon Nuestra Señora de la Encarnacion. The conduct of the case was given to Magistrate Torralba, who, on his arrival at Guam, sent Pimentel in chains to Manila. Notwithstanding his defense of ignorance of the state of war existing between Spain and England, he was sentenced to the forfeiture of the bonds which he had posted on assuming office, and in addition was deprived of his position as governor at Guam. This sentence was rendered January 23, 1712, and was approved by the audiencia in review on July 24, 1714. 226. The tribunal sentenced Pimentel to prison and ordered that his residencia should be taken. Accordingly, an examination was made of all his official acts as governor. Pimentel, therefore, had not only to stand investigation for the particular act which had brought about his removal, but he was also subjected to residencia, covering his entire career as governor. It may be noted that the two forms of investigation were separate and distinct on this occasion. Owing to the death of Governor Lizarraga, to the imprisonment of Boyder, Villa, and to the state of anarchy surrounding the administration of Torralba as governor, Pimentel was forced to languish in prison several years while he waited residencia. The appointment of Luis de Tequil as his successor and judge of residencia was dated June 25, 1717. This occasion was one on which the successor of a governor took his predecessor's residencia, owing, the commission said, to the distance and the irregularity of communication between Manila and Guam. A letter of the audiencia, dated August 9, 1718, advised the governor that there were 427 unfinished cases on the docket of the tribunal, and chief among those that ought to be decided without delay was the review of the residencia of Pimentel. It was added that there seemed to be no prospect that a boat could get to Guam before 1719. The record of the termination of this case probably reposes somewhere in the archives, tied in an aged, yellow packet, bound by Spanish red tape. In summary, it may be said that there were two kinds of investigations of official conduct, one taken at the completion of the regular term of office and the other at any time when the needs of the service required it. They both had the same ultimate purpose of holding officials responsible for misconduct in office, of giving to all persons an opportunity of having justice done to them and of deterring office holders from future misdeeds. practically all of the colonial officials were subject to residentia. The most sensational and widely known residentias were, of course, those of viceroys and captains general, butadores, treasury officials, encomenderos, alcaldes mayores, corregidores, admirals, generals, captains, and constructors of galleons were likewise examined in this way. 227. The visitors and special investigators who were sent to examine the government of the provinces and the state of the Indians on the encomiendas were also subject to residentia. Residentias were exacted of all minor officials at the same time that their superiors were examined. 228. Clerks, notaries, secretaries, alcaldes ordinarios, regidores, and other officials of a minor category were investigated at the same time that the governor was examined, an alcalde or an order being delegated by the new president to review their official conduct. The examination of these minor officials seems to have become more and more perfunctory, and there was a tendency during the latter part of the 19th century to continue them in office, even without investigation. When, for instance, Governors Vasco y Vargas and Marquina gave up their offices, this formality was omitted. 229. The practice of taking the residentias of minor officials was definitely abandoned on August 24, 1799, and a rigid inspection by the audiencia of their official acts was authorized. 230. Much contradictory legislation appears in the laws of the Indies relative to the method of taking residentias. This due to the reforms made from time to time. These laws were formulated for a growing empire. A chronological review of them will show that the residentia was at first more or less of an experiment. Indeed, all the colonial institutions were in the early periods passing through an experimental stage, and these seemingly contradictory laws were promulgated or repealed according to their success or failure when put into effect. Whenever, therefore, two laws appear to be in conflict, the one of later date will be found to supersede and repeal the earlier one. 231. In illustration of this characteristic of the laws of the Indies, we may note the following example. The cedula of December 4, 1630, ordered that the residentia of the governor should be taken by his successor. This law was seldom, if ever, observed. Owing to the distance from Spain and New Spain, and the consequent length of time consumed in voyages, to the unhealthful climate, and to the dangerous military campaigns in which the governors were compelled to engage, death frequently intervened before the successor of a governor arrived. These conditions, which were characteristic of all of Spain's colonies, did not prevent the residentia from being taken, but caused the law to be modified by the cedula of December 28, 1667, according to which judges for the residentias of viceroys and presidents, governor and captains general were to be designated by the court. The period of 4 months, which had been authorized for the taking of residentias by the cedula of August 30, 1582, was extended to 6 months. 232. A change was necessary. The new law declared, in order to put a stop to the incessant strife and the malice which had been shown by viceroys, governors, and ministers in the taking of residentias. The king determined that henceforth the judge of residentias should be designated by the court. The magistrate, usually named, was the decano. After 1776, the regent almost invariably conducted these investigations. The important reform of August 24, 1799, ordered that judges of residentia for governors, viceroys, presidents, governors intendant, corregidor intendants, and presidents of the Council of the Indies should be appointed by the king. 233. The first residentia to be conducted in the Philippines in accordance with the new law of November 28, 1667, was that of Governor Salgado, in 1670. This governor had been removed by the commissary of the Inquisition on October 10, 1668, and Francisco Coloma, the decano, was ordered to take his residentia. 234. Coloma's intervention in the matter was protested by the audiencia in a letter to the Council of the Indies, dated April 7, 1670, on the grounds that the senior order was also the assessor and possible successor of the governor, and for that reason he was disqualified from taking the latter's residentia. 235. The Audiencia suspended the proposed action of Coloma, pending the reply of the Council of the Indies. In addition to the protest of the Audiencia, the fiscal, on May 20, 1670, sent a report of the case to the court, which act was in fulfillment of his regular duties as fiscal, as prescribed by the laws of the Indies. 236. The notes from Manila were effective in bringing about the desired results. Upon receipt of the communications, the Council of the Indies, on June 17, 1671, ordered the nullification of all former sigillas, cancelled Coloma's appointment to take the residencia in question, on the grounds that he had been the governor's assessor, and appointed Fernando de Montemayor, the order next in rank, to conduct the residencia of the governor. 237. Salgado had already been dead 3 years, and 2 more transpired before his residencia was completed and the autos thereof reviewed by the council. The laws provided ample opportunity for appeal in cases of residencia. The sigilla of November 17, 1526, ordered that appeals might be made to the Council of the Indies from judges of residencia, in cases involving liabilities in excess of 600 pesos. 238. Many appeals were made to the council in accord with this law, and the time of the tribunal was consumed in the consideration of matters comparatively of small importance. To obviate this defect, the law was changed on August 7, 1568, to provide that no case could be appealed to the Council of the Indies unless the sentence imposed capital punishment or deprivation of office. 239. The sigilla of June 23, 1608, ordered that if the fine imposed upon the governor and ministers of the Philippines did not exceed 1,000 pesos, the case should be finished in the audiencia. 240. Cases involving a greater amount were to be appealed to the council. Sentence of judges of residencia were not to be executed pending the trial of appeals to the audiencia and the Council of the Indies. 241. Philip IV initiated further reforms in regard to appeal in 1636. Ordinanza LVI, promulgated at that time, provided that the said Council of the Indies may only have jurisdiction over the visits and residencias of the viceroys, presidents, oidores, and officials of our audiencias and accountants and officials of the tribunals of accounts, officials of the treasury and those of the governors provided by the council with our titles. 242. Ordinanza LXAI, issued at the same time, ordered that in the visits and residentias which are seen and determined in our Council of the Indies, cases did not have to be referred to the king for consultation, excepting when, in the residencias of viceroys, presidents, and oidores, alcaldes del crimen, and fiscales of our royal audiencias of the Indies and governors of the principal provinces there, condemnations of corporal punishment, privation or suspension from office result against them. 243. In these cases the council was ordered to submit its decisions and all papers bearing thereon to the king before passing judgment, so that the final judgment might be rendered by the sovereign in person. The council could take final action in the residencias of military and naval officials without consulting the king. It was, of course, impossible for the sovereign to give his personal attention to any of these matters, but the last word was pronounced in these suits by responsible ministers of the court who stood high in the royal estimation. Officials were usually obliged to submit to residencia before leaving the colony, also before their promotion to higher posts. 244. Owing, however, to the paucity of ships plying to New Spain and to the length of time elapsing between sailing dates, officials could give bonds and leave before the resident